law on bribery as set out by my colleague for the petitioner. I'd also like to upload my colleague Counsel Harley for the petitioner for the spirited submissions in support of this illegal practice. Unfortunately for court, and in such election petitions, court is guided by the evidence of the witnesses and the petitioner. And my Lord, as I'm going to demonstrate hereafter, the petitioner and the witnesses miserably failed to discharge that burden. My Lord, the law on bribery, as has been set out by my colleague under Section 80 of the Parliamentary Elections Act, and Section 81 in particular, 81C, that an election of a member of parliament can be set aside if it's proved that an illegal practice or any other offense under this act was committed by the candidate personally or with his knowledge and consent or approval. My Lord, that is the letter of the law. My Lord, 81. Formerly it was 61. But under the new amended revised. My Lord, my Lord, 81C creates the illegal practice. Then 87 goes to bribery. Yes, my Lord. So I was coming, my Lord, from 81C that requires that the illegal practice should have been committed either by the candidate personally or with his knowledge and consent or approval. My Lord, I'm coming from this background because later on, as I will demonstrate, some of the authorities cited by counsel for the petitioner introduce other parameters that are outside the law. And as we demonstrated, some may be peculiar, but I'll read them, my Lord. My Lord, under 87, the offense of bribery itself is introduced. And the ingredients are highlighted there under. My Lord, what I will need to emphasize at this juncture is that the three ingredients under 87 must all be existent and must be proved. Must all be existent and they must be proved with cogent evidence. With cogent evidence. Before court can reach a finding that the illegal practice of bribery has been proved. And my Lord, that is the position as set out by Kizza Message 1, which we have highlighted, 2001. Kizza Message verses 7, which is the locus on this particular issue. My Lord, you cannot prove the alternative. That now, since one ingredient has been proved, then there was bribery. You must bring cogent evidence on each of the ingredients, on the elements. A gift was given to a voter. It was by the candidate. If by the agent, then with his knowledge, consent, and approval. My Lord, I would like to move to the petition, paragraph 20. Paragraph 20 of the petition. The affidavit in support of the petition. My Lord, we have presented and demonstrated to court the effect of hearsay evidence. The effect of hearsay evidence, my Lord has highlighted in the Kizza Message case, the judgment of Justice Order, Justice Odoki, the judgment of Justice Odoki, my Lord, on what should be contained in an affidavit, of the kind, in an election petition. And court, in arriving at this decision, my Lord, was guided by the law. Order 19 Rule 3 of the CPR provides that affidavits can only include facts that the deponent is able of his own knowledge to prove, except in interlocutory applications. Now, my Lord, an election petition like what we are dealing with is not an interlocutory application. My Lord, you posed the question when my colleague Bagenda was submitting that now what happens? The witness makes reference that I got this information from so and so, and those people come and they also give evidence. Is it still hearsay evidence? My Lord, the Supreme Court said yes, it is hearsay evidence. And the evidence that should be considered now is the evidence of the witness who has come. Because what you did, you simply introduced them. But for your evidence to pass the admissibility test under Section 59 of the Evidence Act, it must be direct. You must be the person who saw, felt, perceived the set of facts that you're speaking about. Now, my Lord, the essence of this for an election petition, and I would like to make a juxtaposition as I take us to the petition itself. If the candidate says, I was told by my people that ABCD happened, the presumption is that when that witness comes to court, he will say what the candidate has said that he was told. Now, if a candidate says one set of facts and he claims that they were told by witness X, and witness X comes to court and does not make mention of what the principal or the candidate claims he had from that witness, then it makes the principal's evidence, the witness's evidence, hearsay, in as far as, one, it does not disclose the source of knowledge, or the source which it imputes it to does not speak to the same. And my Lord, I'm going to demonstrate this by the petition before you, to demonstrate that all the allegations of bribery cannot stand. My Lord, in paragraph 20, the petitioner says, I state that before and on election day, the first respondent's agents and campaigners, with his knowledge and consent or approval, committed the illegal practices of bribery. In particular, one, she says, I'm informed by Nakayaana Margaret, which information I believe to be true. Two, says I'm informed by Chamber Mwangusi Nathan, which information I believe to be true. Three, I'm informed by Maumbe Joy William, which information I believe to be true. Four, I'm informed by Wanjala. Now she's telling court that she's informed by these people that with the first respondent's knowledge, consent, or approval, the following acts of bribery took place. Now, my Lord, the duty of court now is to go to the affidavits of these people. And my Lord, when you go to the affidavits, the affidavit of Nakayaana Margaret on page 1267 of the 1267 of the bundle of the petition, my Lord, there is nowhere in the affidavit of Nakayaana, which is 3 pages. It goes from 1267 to 1269. There is nowhere in that affidavit where Nakayaana is stating that with the first respondent's knowledge, consent, or approval, the alleged bribery took place. Because, my Lord, we are coming from the background and it was admitted to by counsel for the petitioner that there is no way on bribery where the first respondent is personally attributed to. So they are not saying that the first respondent is attributed to bribery anywhere. So it means it is agency. Now the principal, who is Nambi, is saying and telling court that the first respondent with the knowledge, consent, and approval, she was told by these people. Now when these people, the witnesses, come to court in their affidavit evidence, Nakayaana does not state anywhere that the first respondent with the first respondent's knowledge, approval, and consent, this bribery alleged here took place. My Lord, that is Nakayaana. When we go to the second, under 20.2, that is Chamber Nathan. My Lord, Chamber Nathan is on 1273. My Lord, equally, Nambi saying that with the first respondent's knowledge, consent, and approval, this witness does not mention the first respondent's consent, knowledge, and approval. And it's a very key ingredient. Now Nambi is attributing this to the witness. The witness does not mention it anywhere in the affidavit. My Lord, the same applies to Maumbe George William on 1276. And the same applies Maumbe George William on 1276 of the petition, and Wanjala Solomon on 1279. Now that leaves us and court with one question begging. From where did the petitioner get the information that with the first respondent's consent, knowledge, consent, and approval? Now, when the petitioner attempts to attribute that knowledge that I was told by these people, and these 4 witnesses on the illegal practice of bribery do not mention it anywhere, then it leaves the averments of Nambi in paragraph 20, 20.1 to 4, hearsay evidence. And my Lord, how do you treat hearsay evidence? My Lord, lucky enough, the Supreme Court came out to serve petitions. Before that, we thought we would have the whole affidavit expanded, and the petition expanded. Because we know, and Nambi was here and testified in court, that she was not there. I don't know what happened, I was not there, but the agents were there, they will say. The petition as it stands with the supporting affidavits, that is hearsay. Now the Supreme Court, in Dr. Kiza Vesky verse 12:7, and the judgment of Sekoko, which is the same as Odoki, they all agree the majority. He says, in my opinion, it would be improper in this petition to strike out the whole affidavits which are found to contain hearsay evidence in some parts, where the offending parts of the same affidavits can be severed from the rest of the affidavit without rendering the remaining parts meaningless. Without rendering the remaining parts meaningless. And my Lord, in a similar case where we had the petitioner relying on hearsay evidence, the Court of Appeal in authority that I've shared, that is Yusuf Mtembuli, it had already been shared to court. Yusuf Mtembuli, my Lord, in this case, briefly, the Yusuf Mtembuli case, I refer court page 16, where the actual decision was, where they were still quoting the Supreme Court decision of Basabye. But my Lord, in this case, the land trial judge was faced with allegations that were set out in paragraphs 118, 119, and 120 of the appellant's affidavit, which constituted hearsay evidence. The paragraphs do not disclose the source of information. Land trial judge could have severed the offending paragraphs and proceeded with the other issues raised in the petition. He did not. He chose to look at the evidence as a whole from both the petitioner and the respondent before coming to the conclusion that he did. The Court of Appeal said, hearsay evidence is severable. And my Lord, in this case following the Supreme Court decision, court severed, expanded only those. And my Lord, is on this point that I'm making a prayer to this honorable court, as I've demonstrated above, that the paragraphs 20, 20.1 to 20.4, of the petition and the affidavit in support of the petition are hearsay evidence, and my Lord, the same should be expunged and severed. My Lord, the sum total of that is that if the petition itself no longer has evidence on bribery because it is not compliant with the law, then the witnesses cannot even come to testify on anything. But it operates like a Russian poison. It collapses. The whole house collapses. When the pillar is cut, the house collapses, and the house of the petitioner on bribery should collapse at that point. But my Lord, in the alternative, and for argument's sake, because we have to respond to the allegations of bribery set out, my Lord, it's our submission, as earlier highlighted, that the petitioner and her witnesses have not discharged the legal duty imposed upon them in proving the illegal practice of bribery. My Lord, I will go to the first instance in the format that our colleague for the petitioner had approached the same. My Lord, that is the allegation under 20.1. My Lord, under 20.1, that is Nambi Margaret. Now, my Lord, this evidence cannot be relied upon by this court for a number of reasons. My Lord, the information itself is contradictory. The evidence is contradictory. My Lord, as you will see later on in the cross-examination, before even we would subject this witness to cross-examination, the petition itself contradicted itself on this allegation. My Lord, I would like to refer to paragraph 20.1. The petitioner says she was informed by Nakayaana Margaret that there was bribery by Nalukoola Rita to Egobe Mary Diana on the 11th of March 2025. That's what the petitioner is telling court. Now, we go to Nakayaana herself. In the evidence of Nakayaana, my Lord, under paragraph 5, is Nakayaana also telling us the same? My Lord, in paragraph 5, Nakayaana is saying that I state that between 5 to 6 p.m. on the 8th of March 2025, Nalukoola bribed Egobe Mary by giving up the same things that they. Now, we are left as court. Now, which of these two should court believe? On which date did this bribery, if any, take place? Is it the court Is it the nature of evidence that you want to be caught to believe? My Lord, the contradiction does not end there on this person. Sebalo to Subida Martin. My Lord, that affidavit of Sebalo to Subida Martin is on 1283. My Lord, this one allegedly is the one who printed. And when the witness, Nakayaana, was before court in cross-examination, she told court that she took these photos to Sebaliba on the 9th and they were printed on the 9th. She told court that she took the photos herself on the 8th of March. But my Lord, when you look at the affidavit of Sebaliba to Subida Martin, and in particular on 1286, where the photos are, the timestamp there is indicating that these photos were taken on the 11th of March. So my Lord, if it's true that these photos were taken on the 8th and they were printed on the 9th of March, then how come the timestamp on the photos indicates that they were taken on the 11th? Is it possible that they could have been printed before they were taken? Is this the kind of evidence that court should rely on to prove bribery? And my Lord, the sum total of this, combined with the fact that even in cross-examination, when the witness was tasked to produce the camera that she used, after heated struggles from even her legal counsel not to let her go, she went home to pick her phone and came back 4 hours later with stories. So the whole chain of this evidence, its veracity, its reliability, is casting doubt and shadows. And as I will demonstrate, my Lord, as I conclude on all these issues, I will only submit at once on the case law. This is not the kind of evidence that could be relied on. And my Lord, most importantly, and this cuts through all the witnesses, my Lord, this witness confirmed to court that she is an agent and a supporter of Nambi. My Lord, even when cross-examined heavily on who the MP of Kawempe North is, this witness was saying the MP of Kawempe North is Nambi. My Lord, as I will later on show with the case law authorities that are available, these are not kind of witnesses that must be relied upon in the absence of independent verification and collaboration, because they are clearly partisan and their mission is to secure a win for their candidate. Even in court, the win that they failed to secure in the field, they come to court and the campaign continues. So as we thought they were in the dock giving evidence, for them they thought they were on a campaign platform. My Lord, I will go to the second incident. Hello, the second incident.